Welcome to the Scale of Justice, a program that keeps you abreast of trends in the dispensation of justice in Nigeria and beyond. I am Chukwunonso Nwabueze. Crimes are part of every society. These crimes in time past were committed by persons that have attained adulthood. But in the recent decades, there had been an alarming rise in the number of child or juvenile delinquencies across the world, including Nigeria. These juveniles may have come face to face with the law and are unfortunately often treated like adults and mixed with adults in prisons or correctional centers. What are the laws that protect children in a juvenile trial? Are the laws active in Nigeria? A case in point being the recent arraignment of minors in a Nigerian court, which at the intervention of the president was struck out. This is the focus of our discussion on the Scale of Justice. We speak with a legal practitioner, Daniel Enwelum, Senior Advocate of Nigeria, who is versed in the knowledge of the administration of criminal justice on the subject matter. Daniel Enwelum, Senior Advocate of Nigeria, thank you for joining us on the Scale of Justice.
Thank you very much.
For the benefit of our viewers, can you, by way of an overview, give us an understanding about Child Rights Act?
Thank you very much. The starting point is the Administration of Criminal Justice Act, Abuja of Nigeria. Section 452 of the said Administration of Criminal Justice Act says, in the trial of a child, the provisions of the Child Rights Act shall apply. It then means that in any trial involving a child, the normal penal code, criminal procedure codes or criminal procedure act will not apply. The court must observe the provisions of the Child Rights Act. Now, what are these provisions in relation to a child in criminal trial? The first one is Section 3, which says that a child is entitled to fundamental rights as provided in Chapter 4 of the 1999 Constitution. And under Chapter 4, it means in the trial of a child, you must observe fair hearing. Under Section 36, you must respect the dignity of the person under Section 35. You must also not subject the child to torture and unlawful detention. That's Section 3 now, amplifying the provisions of Chapter 4 of the 1999 Constitution. Furthermore, Section 5 also talked about the dignity of the child must be respected. We are talking about the Child Rights Act now. Again, Section 16 says that it makes a provision for protection of the child. They call it Child's Rights Care Protection. So these are some of the provisions. There are so many others. But the fundamental is that, one, you do not apply the provisions of the Criminal Procedure Act or the Criminal Procedure Code strictly. You rather apply the provisions of Administration of Criminal Justice Act under Section 452. And in applying that, being guided by that, you go to the Child Rights Act. You must respect the dignity of the child. You must give him fair hearing. And if he's entitled to bail, you must grant the child bail. Then further, the Child Rights Act also provides for the special care of the child. If the child, for instance, is not too healthy, it is the duty, the moment it is brought to the attention of the court. For instance, what has happened in the case of these juveniles that were charged with treason. The problem there was not really issue of should they be tried for treason or not. No. The problem there was were the provisions of the Child Rights Act applied. And if they were applied, the police and prison authorities in whose care they were kept were bound to apply the provisions of the Child Rights Act as to the welfare of those children. So, these are the principal provisions that in every trial of a child, the provisions of the Child Rights Act must apply.
Does this mean when police arrest juveniles, they do not seek judicial advice from the Ministry of Justice before charging them to court?
First of all, the Criminal Administration of Criminal Justice Act provides that in taking the statements of every suspect, but Criminal Administration of Criminal Justice Act calls it defendant. So let's use the word defendant. In taking the statement of every defendant, ensure that he has a lawyer present when he's making his statement. If he doesn't have a lawyer, then you should provide CCTV which will now record what transpired in the course of his making a statement. That is the first step. Now, in the case of a child, we all know a child is not assumed to have a mind of its own. And therefore, in taking the statement of that child, you should bring the parents or guardian. And if they insist on having their lawyer, you should provide that lawyer. I'm aware that the Nigerian Bar Association over time has been pushing for every police station in Nigeria to have a lawyer attached to that police station. This will help, one, like you have asked, giving proper advice, legal advice. And then two, guiding the police in the process of detention, taking of the statements, and generally providing wealth, observing the provisions of the Child Rights Act as to the welfare of the child. So, I may not be in a position to say that police generally don't. I would rather say they are expected to. They should observe the provisions of the Child Rights Act.
Now, according to the provisions of the Child Rights Act, juvenile cases are handled in family courts. How does Nigeria's juvenile justice system operate under this, having adopted the UN Child Rights Convention in 1991?
Juvenile trials are not conducted in the open for the protection of the child. The magistrate usually conducts those proceedings in chambers. So they are not conducted in the open. And like I said, after all the provisions of the Child Rights Act have been applied and the child is convicted without option of fine, he will be sent to Child Correctional Center, otherwise known as Buster Homes. That's where they are kept to serve. In that Buster home, the essence is not to punish the child. The essence is to reorientate the child, mentor the child, and make a better person of him by helping the child to develop some skills that will help him on discharge. So that is as far as the child is concerned, welfare of the child is concerned.
Let's say, would it be correct to say that Nigeria lacks the human resources to take care of cases involving juveniles in terms of the number of social workers employed?
Yes, I think I should agree with you. Why? Because before now, it was not envisaged that the level of involvement of children in crime will be this high. So I agree with you that we lack the resources, but then it now falls on the Ministry of Internal Affairs, under whom we have a correctional centers, to train their personnel, not just in the everyday work of prison administration, but also special attention to care and upbringing and care and mentorship and reformation of children that have been sentenced to correctional centers.
Again, the scarcity of remand and Buster homes across the Federation is said to be responsible for the transfer of juvenile offenders to adult correctional centers. How true is this?
Buster homes are not many. But like I said, I'm not trying to excuse the state. But like I said, it was never envisioned that the number of juveniles getting involved in crimes will be this high. But now that it has descended on all of us, the state has a duty to also build correctional centers, train manpower who know how to handle juvenile offenders, to help in reformation, in mentorship, and in giving skills to all these children in foster homes to come out from there better adults by the time they are released. So I agree with you.
Poverty, social inequality, failed educational system, family problems, and peer pressure, among others, are said to be reasons why children conflict with the law. What is the way out of this?
I will place emphasis on lack of education. Why? Because education opens the mind. And if you have a child that is not properly mentored, that is not properly educated, he is bound to be a delict. And so, my take on it is that primary education immediately should be made free and compulsory across the nation. Within the next 5 years, secondary education should be made free and compulsory across the nation with a punishment, so that parents will not just deliver children and leave them to grow up anywhere they like. Parents should be bound to responsibilities. So, to an extent, I share in your widespread observations, but my emphasis is on education. Let us train our children. Compulsory free primary education, compulsory free secondary education, and then the parents are bound to ensure that their children remain in school.
The major aim of the juvenile justice system is rehabilitation, skill development, and reintegration of juveniles into their communities. Do we see this at play in Nigeria?
Let me add to what you have listed: reformation, reorientation. Those are fundamentals. A child is brought in. Let's take, for instance, thefts. That child may have engaged in such acts of stealing because he lacked food to eat, close to where the basics of life. So when he is brought into custody, the essence is not to punish him or to treat him like an adult. The first thing to do is to reorientate the child. Reorientation will involve inculcating fresh values, making the child realize the difference between right and wrong, making the child realize the need to always aspire to higher values. Without these, giving him skills, as soon as he leaves, he will abandon it. So I am adding that to what the criteria you have stated. Reformation and reorientation should be added. And then, when the child has now imbibed those ones, the child should be made to now realize that going into the society and equipped with the skills, he should thrive.
Senior Advocate of Nigeria, on a final note, what's your take on President Tinubu's timely intervention to halt the prosecution of the minor?
For correcting that error, we commend the president and by extension, the Attorney General and Minister of Justice. He shows he is very active and he is on the spot administrator. So we commend the president for correcting an error that was done by the system. And by the way, talking about the system, our security agencies should up their acts. This idea of collective guilt, collective punishment, it shouldn't come up. It shouldn't. As they are arresting you, at the back of their mind, you committed the offense. It doesn't work. Even the prosecutor, under our laws, must presume that you are innocent, even at the time of arrest. if they can imbibe that attitude of, yes, the facts are leading me to, mark my words, the facts are leading me to believe that you committed this offense, but I'm giving you the benefit of the doubt. If they do that, it will help them in doing proper and thorough investigation with a human face. But what we observe here, once a crime is suspected to have been committed, what they do is to believe, look, you committed this offense. When I was a much younger lawyer, some 30 years ago thereabouts, we went to Zaria to do one case in an Alikali court, and the man came in and sat down. Within that area, it was rampant in the evening or in the night. Some young men, not juveniles anyway, who are fond of parading the streets, bringing out dagger to snatch small valuables from people, and then, of course, harassing some young girls. So we were in court. They brought two boys, and the prosecutor stood up and mentioned, read out the charge. They said guilty or not guilty. The defendants or accused person say we are not guilty. The judge said, now again can the Idokai and leave. Meaning, as I'm seeing you committed this offense. This is a matter of light discussion, but it shows that is the mentality of most of our investigators and prosecutors. They don't have to secure a conviction by all means. No.
Daniel Enwelum, Senior Advocate of Nigeria, thank you for coming on The Scale of Justice.
Thank you so much.
Arising from lessons learned from the outcome of some industrial disputes involving government agencies and their employees, the Federal Ministry of Justice is intensifying efforts at familiarizing state councils in Nigeria with the current thinking in industrial court jurisprudence. The Attorney General of the Federation and Minister of Justice, Lateef Fagbemi, SAN, was at a capacity building held in that regard.
It is common practice that friction sometimes occurs in the workplace, either between employers and their employees or among members of labor unions and trade associations. Efforts at seeking solutions to such industrial disputes gave rise to the establishment of the National Industrial Court of Nigeria in 2006. Since then, it has adjudicated on many industrial disputes, notably cases instituted by the National Union of Electricity Employees as well as ASU, all against the federal government. But government as respondents in some of such cases filed by aggrieved workers sometimes lost their cases due to what was ascribed to the inability of litigators to adequately understand the current thinking and industrial court jurisprudence.
And if the principle is that federal causes should go to a federal court, why should we complain if item 34 is removed and singled out and a special court is made for that purpose?
Addressing this challenge, Attorney General and Minister of Justice says adoption of international best practices and approach to labor-related disputes is the new order.
The role of National Industrial Court, therefore, is very critical to our national interests, and it has the responsibility not only to resolve labor disputes, but also shape the environment in which workers and employers can coexist productively.
Arising from this workshop in Abuja for state councils, they are expected to utilize the critical insights gained to provide winning arguments in support of government's standpoint in industrial and labor matters.
Give honor to whom honor is due. This is what played out when the Chief Justice of Nigeria, Justice Kudrat Kekereekun, and the Attorney General of the Federation and Minister of Justice, Lateef Fagbemi, SAN, led other members of the bench and the bar to extol the judicial pronouncements of late retired Justice of the Supreme Court, Justice Olayinka Ayola, for upholding the banner of justice, equity, and fair play when he was in service. This was at a valedictory court session in his honor held at the Supreme Court. The Chief Justice of Nigeria, Justice Kudirat Kekereekun, who led other justices of the Apex Court to the special court session, paid an outstanding tribute to the late Justice Olayinka Ayola, whose service to the nation's justice system remains a reference point to members of the bench and the bar.
His judicial pronouncements have deservedly occupied vital pages of law books across Africa. He was a quintessential judicial icon who bestrode the judicial landscape with honor and great panache. He believed strongly that a judge would decide cases without fear of failure, affection, or ill will. He was courteous to all, yet his politeness never invited disrespect. He always endeavored to employ plain, precise, and pointed language in all his judgments.
The Attorney General of the Federation and Nigeria's Minister of Justice, Lateef Fagbemi, SAN, including the Chief Justice of the Gambia, Hassan Jallow, who was represented, lauded remarkable contributions of the late jurist to the promotion and preservation of the rule of law.
In 2001, he was appointed chairman of the Committee for the Revision of the Laws of the Federation of Nigeria, that is 1990. He ranked among the very few Nigerian judges that have shaped the course of justice beyond the shores of Nigeria and set many milestones in different fields of human endeavors. In all of these positions, he stayed true to his high standards, which he set for himself, and distinguished himself as a judge of great character with extraordinary commitment to the cause of justice. Late Honorable Justice Ayola's legacy continues to endure through his numerous landmark cases and judicial pronouncements. He severally distinguished himself through many of his well-researched judgments.
Having interacted with him personally, professionally, and throughout his tenure in the Gambia and in Sierra Leone, he loved the Gambia and he loved its people. He served the Gambia with the highest standards of professionalism and dedication. He contributed immensely to the development of his jurisprudence, as evidenced by the continued reference to the reliance upon his judgments in our jurisdiction, to the strengthening of its legal system with many reforms and innovations. In that way, he contributed strongly to consolidating the rule of law and the respect for human rights in those days when the Gambia's record in the field of good governance was widely acclaimed. He was a bright star in the chain of jurists who contributed to and enhanced the long tradition of the excellent judicial cooperation between the Gambia and the Federal Republic of Nigeria.
He was at a time, one of the best that ever adorned the bench of the highest court in this land. His judgment lie in the law reports and records of this court, and they shall forever speak for erudition, justice, deep learning in the law, and humanity in Justice Ayola. Many of us advocates who appeared before him, including myself, my Lord, will forever remember his candor, truthfulness, genuineness, free from hypocrisy, and above all, his faithfulness to his oath of office as a judicial officer. Many will attest to his integrity, compassion, and reliability as a lawyer.
This Ayola's remarkable legacy is perhaps most clearly illustrated in the impact of his judgments and legal philosophy. His landmark pronouncements in states against Ogbulafo, citation provided, and Fawaimi against Abuja, citation provided, emphasized the judiciary's role as the ultimate protector of the common man's rights. His belief that justice delayed is justice denied is etched into our jurisprudence, a guiding star for legal practitioners who seek to uphold the dignity of every Nigerian citizen. His conviction that the law must serve all, irrespective of status or power, stands as an unassailable principle for the Nigerian Bar Association.
With over 5 decades of impeccable judicial career, late Justice Olayinka Ayola, a former chairman of the Independent Corrupt Practices and Other Related Offences Commission, ICPC, died on the 28th of August 2024 at the age of 90, having served at various judicial positions on the bench, culminating in his elevation to the Supreme Court in 1998. Between 1980 and 1999, Justice Ayola was seconded to the Gambia and Seychelles, where he rose to serve as the Chief Justice of the Gambia and President of the Court of Appeal in Seychelles. This is where we end the program. Watch out for another insightful package. Thanks for watching. I am Chukunonso Nwabueze.